So I got a great question from our Legal Leverage Facebook group. And if you're not familiar with our Legal Leverage program, you can go to our website. It is an online program that helps you walk through how we would evaluate bringing a claim against your employer and how you can try to do some of that work yourself to analyze your own situation, whether you are trying to go on your own without a lawyer, or you decide you want to hire a lawyer and you want to be an educated consumer and understand how they're thinking about your matter. And as part of that, the Legal Leverage program, we have a Facebook group where people can post anonymously issues that they are dealing with in their cases. And I got this one, which asked some really good questions, particularly about high-profile cases, some of these really famous whistleblowers in various industries. And the question is, there are three parts here. The first one is, how should statutory caps be viewed in light of multiple claims under, for instance, the False Claims Act, Title VII of the National Labor Relations Act, OSHA? How are you to think about this when negotiating these kinds of settlements? Great question. So caps in these laws basically mean caps on damages, or what you can potentially win in a lawsuit. And unfortunately, Title VII, which is the big anti-discrimination lawsuit, has caps that were set in 1991 and have never been raised. So as you can imagine, there's been a significant amount of change in our monetary system, namely inflation, since 1991. And so dollars in 1991 are not worth nearly the same today that they would have been then. So the caps are really very low. And for Title VII, there are caps based on the size of the employer on what's called compensatory damages, which basically are things like emotional distress, or punitive damages would be compensatory damages. Those kind of damages are capped. The highest level you can get under Title VII, and this is with employers with 500 or more employees, is $300,000, which is pitifully low. So if you've experienced really severe emotional distress, so you go before a jury and they give you a seven-figure, multi-million-dollar award, a court's going to cut that down to $300,000 because that's what the cap is. So it means that the exposure that these companies face is not nearly enough to make them change their ways in a lot of instances. It can bring justice to you, the individual, but it's not going to move the needle a lot for these companies. And in certain really extreme circumstances, the value of your case is going to be very much undercut. That said, I think for most of us, if you have that kind of a claim, if you can get a good six-figure settlement or judgment, that's not bad. But nevertheless, the caps are low. So the issue is, what about laws that don't have caps? And there are laws that don't have caps, and that's really part of the strategy in bringing these cases. For instance, let's say you have a race discrimination case. You can bring that under Title VII, which is the big anti-discrimination law, or you can bring it under a claim called a Section 1981 claim. Same claim, both race discrimination claims, but under Section 1981, there are no caps, right? And there are other differences. This is kind of a tangent. Under Title VII, you have either 180 days or 300 days to bring a charge with the EEOC. If you don't do it within that time frame, you lose your right to sue forever. Under Section 1981, you don't have to file with the EEOC, and you have, in most states, you have 4-year statute of limitations. So it's a great question, and absolutely, working with your lawyer, you should consider, if you can bring multiple claims, and particularly claims under laws that do not have a cap or have a more generous cap than Title VII. And this could include state-level claims. So, for instance, if you were to bring a charge of a race discrimination or sexual harassment or a wrongful discharge claim of any type in the District of Columbia, you can bring it under the DC Human Rights Act, which also does not have caps. And it's often not either or, right? You can file in the same complaint, you can file Title VII, you can file 1981, you can file them state court claims, you can throw the whole kitchen sink at them. The reason for doing that is, A, you want as many of your claims to survive as possible, and B, you want to have claims that have the maximum possible damages because it raises your leverage for a good settlement. And certainly if you get to trial, it raises the possibility that you're not going to get a substantial verdict later cut down by the court because the law says you're only entitled to so much. So you bring all those claims. And if you were to win on all of them, then you don't get multiple bites at the apple. You don't get damages under Title VII, and then damages under Section 1981, and damages under the DC Human Rights Act. You would just get one award that would cover all three. But again, if you've got a case that, a statute that just does not have caps, then that award is less likely to be cut down. So thinking about the caps and being strategic about that is very important. The other part of this question is, does there come a time where, as a matter of public safety, settlement is inappropriate and or unlawful? I think public safety, individual safety of a whistleblower, we just had a whistleblower based on news reports, commit suicide, a whistleblower in the airlines industry. Who knows the exact reason that he did that, but obviously the stress and the pressure is tremendous. The retaliation can be tremendous. So, even bringing the claim is likely going to invite those kind of responses, particularly if you are filing in court where those claims are public. And you should be working with an experienced lawyer who can help you as best as possible deal with that, because this does happen often enough that lawyers that are experienced in this area have some tips and tricks for dealing with it. But in terms of settlement, I don't think a settlement in and of itself that I can think of is going to make that situation worse, right? It's already probably going to be, because you filed. CNN, the Washington Post, Fox News have all reported on it, and whatever's going to happen in terms of retaliation against you is already happening. A settlement can only help resolve that, usually, because you're ending the matter, right? Hopefully it's a good settlement for you. You're getting a monetary reward that, if it doesn't make you whole, at least allows you to get to the next best thing in your life. There may be other bells and whistles that are very advantageous to you. And then, of course, it kind of turns off the spigot for the defendant to be retaliating against you, or their friends to be retaliating against you. Does it completely stop all of it? No. But it turns down the heat significantly. In terms of being unlawful, there are some laws where a court has to approve the settlement. The Fair Labor Standards Act is probably the most prominent one, which, as the name suggests, governs your right to pay at work and right to overtime and some other compensation issues. For those cases, in most instances, a judge has to approve the settlement, because the judge has to make sure that it is fair to the employee or to the class of employees if it's a collective actions kind of case. And there are some other instances where a court has to be involved. In most, a court does not. So, for instance, if you're going to settle, this questioner asked about a Title VII, claim brought under the Americans with Disabilities Act, a court does not have to approve that, and there are very few things that would make that kind of settlement illegal. And attorneys on both sides who deal with this are very conversant, very knowledgeable about the various provisions and which ones are controversial and which ones are not. So your attorney should be able to help you walk through that. There are some things on the, in some cases, like sexual harassment cases, depending on how the case was brought, there may be some restrictions on the non-disparagement provision, which basically is the provision that says, hey, you can't go out and say bad things about the company. It can also bind the company and make sure the company doesn't say bad things about you. There's some relatively new laws that limit that power. But for the most part, it's between the parties as to what the provisions say. So again, there's some claims that do require court involvement. They tend to be the minority. In most cases, settlement is up between the parties, and there are very few things that would make that settlement illegal. But hopefully, you're working with an attorney who does this work and will be familiar with that, and will help you kind of navigate, kind of alert you to things that might be problematic to you, or a language that you want to change or include, or otherwise make the actual, because it's a contract between you and the party that you've sued, making that contract fair. And then the final one, how should one weigh the risk of disclosure of this information against the risk to their own safety? That's a great question. I wish, in a just world, people would be able to bring these claims, have courts consider them without experiencing, very significant retaliation. I think this is a personal decision, certainly one you can discuss with your attorney. There are a lot of things that can happen before you file a charge, if it's a claim that you have to file a charge for, or before you file a court case, that mean that it's not public. And obviously in those situations, if it's not public, then you're not going to get every Yahoo, who has an internet connection, who's upset with you, kind of reaching out to you, or at least makes that less likely. The problem is that kind of those pre-suit activities, they don't put a tremendous amount of pressure on the company, and they rarely get a company to change. They can get a company to write a check, and if you've got a really strong case, you've got a lot of documents, it's not uncommon for a company to be like, oh yeah, okay, we'll write a check because we want this resolved, we want the settlement agreement. But because you haven't really ratcheted up the pressure on the company at that point, in most cases, because what these companies care about, right, is the public pressure. So, are the news reports, are what congressional investigators might do after being alerted to this issue by the whistleblower. That's what they're worried about, and that requires that you go public with it in some fashion. Whether it's through a press release or whether it's filing a complaint in court, which are all public. It requires you going public with it, and that's going to necessarily bring the heat if it's a particularly high-profile matter from people that you don't want to hear from. And so it's really a personal decision, like how much of your life do you want to devote to it. It's not uncommon to have situations where you hire an attorney, you send a demand letter to the company, and the company writes you or is willing to write you maybe not everything you ask for, it's usually rarely everything you ask for, but a sizable check. But as part of that, this allows them in some sense to sweep it under the rug because they don't want it public. That's one of the reasons they're writing the check. They want the non-disparagement. They want to release the claims like this thing is over. But it means you are less likely, not zero, because he may be still experience retaliation for the company, but less likely to get retaliated from, again, somebody way out in the dark corners of the internet because they never learn about this. And so you may have a decision to make with you and your family, like how much of your life are you willing to put on the line here, at least in terms of your reputation, the distress that you're going to feel from this, how much just doing the right thing matters to you. And there's no right or wrong answer to that. For some people, they want to right the wrong and they're going to go all the way. And in that instance, you can file the case, put maximum pressure on the company, hope you win some changes, but understanding that it's very possible that your life is going to be a living hell. I will note that it depends on the level of the case, right? Like if this is a case, that's going to get national attention, then absolutely you're gonna hear it, right? If it's less than that, but still, let's say very bad. Let's say you're bringing a serious hostile work environment claim against a big Fortune 500 company. I think people sometimes tend to overestimate how much the press is going to pay attention to these issues, because often they won't, right? Because the Fortune 500 company getting sued for any particular reason is not big news, right? They're sued all the time. So if you file, you're an individual and you file a sexual harassment case, against your manager, let's say it's a fairly low-level manager at this Fortune 500 company, maybe the specialty press will pick it up, so kind of the press that writes for lawyers might pick it up. It's going to be on the internet, but it's, CNN's not coming down, Fox News is not coming down. It can be unlikely unless your case is really, again, one that commands national attention, and sometimes that can be a little hard to tell. So again, talking with an experienced lawyer about this, about what public pressure you may face from this can be helpful. So there is a range in terms of like what kind of blowback that you can expect. So I appreciate those questions. Those are great ones, and we will put this up on Legal Leverage, and I encourage folks to join it.